But one case outside the list, but there is Supreme Court 22 of 2020, which its duty court has not granted much time, but there will be difficulty in this matter. Moderate this.
What is your ground?
But the ground is that in spite of the finding that there is a composite negligence of both the vehicles, both the insurance companies are party, entire liability was under error of record of being fastened upon us. There is a finding was. Okay.
From the list, I'm paying for not today in item number 31 also from hearing matter person.
After, on the request, after summer vacation?
Yes.
Summer vacation. SA 92.
Yes, sir. Yes, sir. Much better.
From supplementary causes under the deforestation, serial number 1, MA number 39 of 70, Mr. Ramchandra Sahu.
My Lord, this matter was earlier argued. Before I further argue, 2 points I want to, my Lord, bring to the notice of this court. Yes. My Lord have called for records of this case. The Lordship may kindly see the order dated 20th of September 2004.
20th of September?
Yes. Well, two persons, one known money murder and Tuplal murder, your Lordship has filed intervention.
That was dismissed.
That was dismissed. Against this, they preferred a writ application before this court. As because the final order was passed in this probate case, that it become infructuous. Thereafter, they have filed a writ application for challenging the cancellation deed disputed by Pune. That writ application will be allowed. And as per my
Cancellation of?
cancellation, a deed of cancellation was disputed by Pune.
Deed of cancellation of what?
Of sale.
Sale.
Sale. The Pune had disputed sale deed in favor of her daughter Dhalia, and she has disputed 2 sale deeds. One is in favor of these the beneficiaries, and another in the favor of the two murder and father of the known Mandi murder.
No, just a minute.
So these are issue of title, there is no doubt.
No. Let me. There's a will.
Yes.
Will is in respect of a particular property.
It is in respect of three properties that we have categorized in A, B, C.
Will is in respect of 3 properties.
See, some of which are Raiti properties, some of which are Rajurga class,
They
etc.
are please serious. Then it is well settled that in the case of probate,
Money.
the challenge is limited to the genuineness of the
Okay.
probate.
Those judgments have.
Show me the judge, please.
The judgment your Lordship is 1993, SCC.
How many judgments you are citing?
It is Chiranji Lal Srilal Goenka, it is the 1997. Then 2 more judgments, Krishna Kumar Barelia, and
That is 2000?
and it is and another one your Lordship Kamarjit Singh Dhillon.
Huh?
Kamarjit Singh
Dhillon.
Yes.
2007.
Yes. These judgments are well settled. But as because to bring a counsel for the petitioner, it is my duty to bring every fact before you.
That
And today I was going through the judgment. Admittedly, those sale deeds, your Lordship, and the cancellation deed relates to this property. Yeah. Just on my part of it.
execution of a will doesn't make you the title holder of the property.
That is well said.
Even if the will is in your favor,
Mine.
in respect of a particular property, if the respondent can prove that the title has not passed.
Yeah.
Because the person who has executed the will has not derived any title. He will not.
Yes, law is well settled,
Law is well settled.
that so far as the
Title
deal is
suit,
concerned,
numbering this
it has.
application as a title suit doesn't mean that the title is in respect of the land.
Yeah.
That is the genuineness of the
Yes.
will instance.
And apart from that, the readiness, your lordship, the testator has to, not only the attesting witnesses, but has to say that the testator has signed in mind. Those aspects have been considered. But under erroneous impression, pass this order.
My contract will see at page 47.
Senior Supreme Mr. Counsel, what is the provision of contract? Come to the appeal judgments. This is an appeal. Come to the appeal judgments. Complaint is in writ application. It's a basic pleading. And this year the basic pleading is already over. That is the your application for probate and the contest. On what ground this probate application has been dismissed?
Grounds, your lordship may kindly say.
Just a minute. On what ground this probate application is dismissed? What are the reasons? What are the reasons? The score
After 5 p.m.
काउंटर कहाँ स्कोप कहाँ है भाई सब में काउंटर कहाँ का ही करते हैं स्कोप कहाँ है What is the scope of counter affidavit in an appeal? Tell me, what is the scope of counter affidavit in an appeal? Scope of counter affidavit is only in the writ application. Scope of counter affidavit is only in a writ application. On what ground this order was passed? What are the grounds? Up to paragraph 12 is the application details. Paragraph 14, 13 onwards is the written statement. Paragraph 21 to 24 is the argument of the states. Paragraph 25 to 23 is the 25 to 33 is the argument of the applicant. Paragraph 34 is law, 14 section 281, 68. So out of 11 pages, 9 pages gone. The conclusion is paragraph 36. So let us read paragraph 36. Yes, you want to intervene?
No, I just want to tell you one thing.
You want to take classes in the chambers? You take classes in the chamber, in your chamber.
Why did they come?
Take classes in your chamber. Or in a law college. Yes.
Paper 36 appraisal of the record is appear that the
So you agree with me that up to paragraph 35 there is only this quoting. Now paragraph 36 read.
appraisal of the record is appears that the prisoner
He
has
used the mic listen also.
filed the instance case for granting probate of which tested by 1994 made by Muslimat Sonia Devi in prisoner in respect of property is described under Schedule ABC of the plan. But I rather find that the one we dated 1994 which had been tried by Ram PW3 and this PW3 also one of the veterans who are who has stated that he has described under the instruction of Bunyadi. PwC has stated that Bunyadi ATI 181 and the attesting witness Ramdev Mathur also signed in his presence. PwC Gola Mandal also attesting witness to the bill for bit 1. It is relevant that the 1 and the 4 petitioner who has also signed on the 1 and in this way the petitioner have wanted to establish their records before the court.
Just. So, paragraph 36 to 41, he says that the exhibit 1 is the will, the scribe is so and so who has proved. The scribe also proved that it was drafted on the instruction of Punia. He stated that PW3 further stated that there were attesting witnesses were Ramdev Mahato. Gola Mandal said that he is an attesting witness and they have also signed. So up to this is the finding. So this finding doesn't reflect anything against the will or execution of the will. Now come 41-40.
I further find that the land share they are tending to Katha number 33 of 49 of village Katwara and Katha number 38, 71 of village Pasarati are admittedly that Durga Khas land and with regard to this point the land and the land council to the OB has raised the question before the court that unless and until it is proved that the testator acquired the right there our decision cannot be granted in favor of the petitioner. The other point it has been raised by the OB that after coming into cooperation of Bihar Land Reforms Act 1950, that Mudurwa land in absence of various settlement vested in the state and collector, the probate cannot be granted. The third most important question before the court that the petitioner have not filed original Nama Zamindari and received government and received land possession certificate copy of register and register two of the associate Mudurwa land, and these are the most important documents for verification of issue number 1 and 3. Having regard to the above fact and chances it can be said that the petitioner have not been able to his case properly and as such in absence of the proper documents the probate cannot be granted as such the case of the appellant's petitioner is here.
So what is the ground of dismissal? So what is the ground of dismissal, Mr. Counsel? Tell me. What is the ground for dismissal? Title? Ground of dismissal is the title? Is it not? Where is issue number? Where are the issues? Where are the issues? Where are the issues? In the entire judgment? Where are the issues?
May I submit?
Mr. Counsel.
Yes, Lord. Lord,
Even the best doctor in the world can treat a person who is alive. If a person is dead, no one can treat that.
Definitely not.
So this is a dead case.
Definitely not.
Even you cannot.
Definitely not. We are not just man.
This matter has to be remanded.
Definitely not. That is what I was about to submit. That in probate case there is no title cannot be looked into.
Take out. Heard the learned counsel for the applicant, Mr. S. K. Sharma, and heard whose name? Your name.
Yes,
As per the both, दोनों का नाम लिखिए. So and so appearing on behalf of the respondents. This appeal can be disposed of at the stage of admission itself, as the local records are published in court and has been received by the respondent. Yes, sir. Next. Agreed with the judgment passed in probate case number 5 of 2010 by the district judge to Biridi and by judgment dated 19th August 2016. This appeal has been referred by the applicant's petitioner. Petitioner, as the probate case has been dismissed. The council, next one, the council appearing on behalf of the appellant submits that the learned district judge to Biridi has completely misdirected himself while dealing with this probate case. He submits that the basic principle of deciding a probate case has been done away with by the district judge to Biridi. As per him, the learned judge concentrated on the title of the property which was bequeathed, which in fact cannot be a consideration while granting probate. While granting probate, the court has to see the genuinity of the will. Just yes.
Apologies for interrupting me. There is also a provision for appeal in section 299 of the Indian Succession Act.
Yes.
Appeal against the order of the district judge.
What is this?
They should have preferred the appeal before the
Before? Order?
my apologies. Actually, I got carried away before.
Before?
Dots.
Continue. Before?
Maybe before dots. That is, I misread the provisions. Apologies.
The probate case is filed before the district judge. It's not before the cadet junior to the judge. 299, this is an appeal under 299, which is registered as a miscellaneous appeal. It's not a regular first appeal. Under 96. Jeremy? Huh?
The court has to see the genuinity of the will.
Genuinity of the will and whether it has been properly executed or not. He submits by going through the impugn order. He submits that there are no reasons. The reasons which have been assigned in the impugn order for dismissing the probate case is unknown to law. He refers to several judgments of the Honorable Supreme Court of India in support of this contention. The learned counsel appearing on behalf of the appellant submits that admittedly, the respondent submits that the submits that Unwa, Musabat Unwa Devi, cannot be said to be the title holder of the land which she had bequeathed. In absence of title, cannot execute the will. Thus, the district judge to Biridi had passed an order dismissing the probate case. After hearing the parties that go to the CR and the interim judgments, the order of records and the interim judgments. From the interim judgment, I find that one Musammat Punia executed a will on 23/8/2000 or 1994. Musammat Punia, wife of late Atu Manda, were in favor of, so 1994 in favor of the appellate petitioners. After the death of Said Musammat Punia, the petitioners here, the appellants here, filed this application for grant of probate. The learned district judge, 2, Girini, after considering the evidence led by the plaintiff, the applicant's petition, concluded that probate cannot be granted as the petitioners have not filed original hukumnama, zamindari rent receipt, government rent receipt, land possession certificates, copy of return of register 2 of the land, the learned district judge further held that the land is Gair Majura Khas and the plaintiffs could not, and there is nothing to prove that the land was settled in favor of Punia, Musammat Punia. On that ground, this application was dismissed. Thus, from the reasons for dismissal, the reasons of dismissal is the title, is whether it is the reasons for dismissal is based on the question as to whether the testator had title over the land property question or not. This issue has been set at rest by the Honorable Supreme Court in the case of Swanso versus Swanso 2007, Volume 11, SC 65. Case has held that title of the testator in the suit properties can only be decided by a civil court on evidence. The Honorable Supreme Court further held that it is true that the probate of the will granted by the competent court would be admitted into evidence that may be taken into consideration by the civil court while deciding the suit for title, but grant of probate cannot be decisive, but declaration as to whether at all the testator had any title to the suit property or not. Thus, this clearly in the opposite judgment, the Honorable Supreme Court took note of the judgment passed in Chiranjilal Srilal Goenka versus Jasjit Singh, 1993, Volume 2, SCC 507, wherein the Honorable Supreme Court in paragraph 12 emphasized that probate court does not decide any question of title or of the existence of the property itself. Thus, from the judgment of the Honorable Supreme Court, it is very clear that the court, while deciding as to whether probate has to be granted or not, cannot go into the title of the property which is sought to be bequeathed by virtue of the same. In this case, I find that the learned judge has solely dismissed the probate case on the ground that the documents of title were not produced. Document of title of the property, which was sought to be bequeathed by virtue of the will, has not been produced. While deciding an issue as to whether probate has to be granted or not. This finding can be erroneous, illegal, and against the provision of law needs to be set aside. Next slide. Before parting, I find that this judgment dated so and so past this one, so it's set aside. First up, the district judge needs to set aside. First up, the matter is remanded to the court of the district judge to pass a fresh order in accordance with law after considering the evidence that this appeals has give us slip. Flying notes. Time.
नहीं, because one case of mine is pending. In that case, I am dependent. I have taken the same ground. I have got the judgment today itself. This is what I am asking for you. You give that.
Today.
It is not listed today. It is not today.
Serial number 2, MN number 511 of 70.
You are asking for the judgment.
Yes, this one, because that will be against me. So I am
He
not.
will not give you any judgment.
He will give me. I will not.
Because you don't give any motor vehicle judgments to anyone.
No, I give. I have given. I give. I give.
Yes, next.
But in this case, this matter was argued on the last occasion only the point of interest and the point that whether interest can be granted on the future prospect of income. Because on the future prospect, it is something which is to be accrued in future, not on the date of death. It accrued to the deceased or his family. This is something which will be accrued in a notional manner. So whether the interest can be given on a notional income which is likely to be accrued in the future. So that is the first point, interest part. And interest part, I have given one judgment of the lordship on the occasion. Last occasion.
That means you mean to say that as per Pranay this 30%, 25%, 40%.
That will be given, but the future income part is the interest part is concerned.
No. So that will not carry any interest.
Yes, that is the judgment of Honorable Guwahati High Court, and that is this is the recent judgment of the Government of Guwahati High Court. And on the point of income, what was the rate of interest?
No, rate of interest will come later.
Yes,
This.
yes, this is the judgment. You want to kindly see in this case, paragraph 5. Paragraph 5.
Come to 171.
Yes, you.
Come to 171 of the Motor Vehicle Act.
Yes.
So if you say that this enhancement of 40%, 25% and 10%
Yes.
will not carry interest,
Will not
that
carry.
means this court has to hold that, come to 171, where any claims tribunal allows a claim for compensation under this act, may direct that in addition to the amount of compensation, simple interest will also be paid at such rate. So
At such rate.
this 10%, 20%, 30%,
But-
is not included in the
Not
compensation.
included. But in the thing, in this case, as per the Motor Vehicle Act, as per the Motor Vehicle, as it was there, because under the Motor Vehicle Act, the multiplier method is the adopted method. That is the statutory provision. But this future prospect part, that is an enunciation by the Honorable Supreme Court in transition. So therefore, this paragraph.
No, so the conventional head,
Conventional head that is there. But conventional head, but it's also no, not conventional head also.
yes.
But the Honorable Supreme Court, keeping in view of the situation and the price rise,
So where is the conventional head?
yes, kindly come. That is there. That
Yes.
part is there.
Let us,
That part is there. Of course, yes.
where is that? So,
That conventional head, my lord, general damage in case of death,
what you are reading?
this schedule,
Schedule, which schedule?
this schedule 163, schedule
163.
168 schedule.
Why should I give to 163 in our case 166?
No, as because the multiplier which is being applied is in ratio of the C163A.
No, we don't know. Should
Multi-
Ganesh Shetty and that this multiplier or Sarla Verma?
No, Sarla Verma has been a development with regard to the multiplier because therefore in that case the Sarla Verma is the multiplier method. The multiplier is basically from the 163 schedule. Even if you go to the Sarla Verma, the multiplier is a derivation from the schedule. So
You admit that multiplier is a derivation from the schedule.
Deviation from the schedule, there is a derivation from the schedule, not derivation. But in this case, for general damages in case of death, the statute also provides something is to be paid.
163.
163, but there is nothing. This is the method. The under 166A, there is no calculation how much amount is to be
You
given.
are saying, I am asking this question because you are saying that this enhancement on account of future prospect is not a creature of a statute, it's a creature of
These
judgments.
pronouncements.
So it will be out of the purview of the definition compensation as in 171.
Yes,
This is your
this is my subject.
established, you just
Now,
you just develop this argument.
yes, the under the motor
So
vehicle act.
now let us read 171.
No, let us read 160 or 66 first.
No, first read us
171. Let us read 171. 171. 171 is only with regard to the interest part. Nothing
Yes,
beyond
interest on what?
that. Interest on compensation.
So what does this
But the
compensation mean?
compensation, I am coming to that one. Compensation is something which accrued to the deceased's family on the date of his death. But this part
Just a minute, stop it.
is
As per you, the death of the deceased.
death of the deceased.
Show me any citation.
But I don't have any citation on that. But in this case,
This is for the first time. There is no citation on this one.
there is no citation. But the old judgment, Your Lordship, that Sushma Thomas case.
Yes, show me. Sushma Thomas Tikal,
Sushma Thomas case, 1994 Supreme Court.
94 Supreme Court. Compensation, then we have defined what is compensation.
No, what is to be Charlie and David and all those things, there are subsequent there too. I have got those books today.
Because how can that be? You have come to argue that the compensation word doesn't include the future prospect. There is something alien to the word compensation in terms of 171. So to exclude this, you have to satisfy the spot that this future prospect is not included in the word compensation.
Like, it is included, but the thing is that, but in
No, let us be one. Either it is included or not.
No, I am coming to that, madam. I'm coming to that. How this Pranay has come? Pranay
That is your backup. That is the backup of your theory. How you reached at a conclusion. First, tell me what is your conclusion. Is compensation, is this future prospect a part of the word compensation as mentioned in 71 or not, 175?
Well, in this case, again, I would refer you to the judgment of the Honorable Guwahati High Court, which I was referring to. Paragraph 5. Perhaps I have not given that.
No, this is Guwahati.
This is Guwahati,
No, this is Supreme Court opinion.
Supreme Court.
What is Guwahati?
Initially, the appeal was
What
preferred
is Guwahati?
against. Yes. Paragraph 5 में कहीं भी see. Five.
Yes.
5.
The Honorable Guwahati High Court says, it is now the settled position of law that no interest can be imposed upon such income of future prospect, and that being so, interest that has been awarded to the tribunal has to be dismissed.
But it is that interest has been taken away. That interest.
Yes. Now, it is now the settled position of law that no interest can be imposed upon such income of future prospect.
Future prospect.
Show me that settled position. Just merely writing in a judgment that it is a settled position of law will not make the proposition settled. Show me.
Now, in order to explain this,
Show me that.
but
You relied on it.
I relied on
This is not a proposition of law. This
This
judgment.
is not a provision, but the judgments which have been
This judgment is
Some-
not a proposition of
Madam,
law.
in this case,
It
suppose
says that it is a settled proposition
settled
of law.
provision, but there are two
As
cases.
if
Now,
that there are several judgments.
yes,
Show me what is the settled
but
proposition.
these are the two judgments, two cases which have been referred to. That is, these two maybe not a reported judgment, but those judgments are there on the Honorable Guwahati High Court, which have been referred to in coming to this conclusion that is.
Show me that. Show me that.
But I'll let it be some other day. I'll find out.
How a proposition of law? Then my next question is, how a proposition of law is set? Let us understand.
Now, the proposition law is that suppose there is this Pranay Shetty taken into consideration.
How a proposition of law is set?
Settled,
Forget
because-
about Pranay.
No,
Forget
because-
about Mumbai.
Now, in this, but suppose
Now, the proposition first, listen. Let us understand step by step. I can't go very fast. For a proposition of law to be settled, there has to be a proposition of law first.
yes,
So, what is the proposition of law which you have made? That future prospects will not carry interest.
interest.
Because what will happen in future, keeping in
Nobody
consideration what is happening in future, we are
Uncertain.
we are uncertain, so we are giving, we are awarding some amount, so that amount should not carry interest. This is the proposition of law. Now, a proposition of law has to be answered, and it is settled when there are series of judgments
On that issue.
on that deciding that aforesaid issue.
So, at most humility I am submitting because the learned judge has referred to two cases of the Honorable same High Court,
The proposition of law can be said like this:
that if it is a
that
precedent,
a person who has entered in the service in a backdoor method has to go out in a similar manner.
similar manner. So,
There has to be go out.
With
So
utmost humility.
this is the proposition of law which is settled in view of several judgment and including the judgment which can be established.
Utmost humility I am submitting.
So this is for settlement of a proposition. Show me that this law is.
This in this case, utmost humility I am
If you want time to address this issue, you take time.
These two
Once you have raised, I will answer this.
yes, these two judgments which have been referred to by the learned single judge, those has to be gone into.
Why are you asking me?
That's
Because
so
what
I'll have to go through it because
So you should have.
I will have to go through it.
You are raising a proposition of law. You are asking this court to enter into an uncharted avenue. So you have to take me, otherwise I will go wherever I like. It is the duty of a lawyer
Yes,
to
but
take
I was armed
the
with this
judge
one.
along with it.
I was
If
armed with this
you
one.
don't take the judge along with your arguments, the judge will definitely
Haywire.
go haywire. He will ask you several questions.
So therefore, what I
You
was
try to keep the judge confined in your path.
I was not aware. I'm not because this judgment. Otherwise, I going through this judgment, paragraph 5. I should have gone through these judgments. Certain provisions are not aware of those judgments. Orders passed by the Honorable Guwahati High Court in what the law has been settled. What the law has been settled.
And second,
As
question is, I'm giving all this question because you can address next time. What is the binding effect of that Guwahati High Court judgment, single judge judgment?
no, this is not binding. It is not a binding. That if my lord is putting that question, I will not reply upon it. Simple. Because that has not a binding.
That is also second.
But the thing is that I was putting a question to myself whether suppose if a judgment by my learned one of my friends.
I may take assistance of the judge.
Yes, assistance only. Only to the taking assistance, nothing beyond that.
Assistance of the judge.
The only assistance, nothing beyond that.
Provided
It's
the judgment is a decent judgment,
based on the series of judgments.
based on the proposition, certain proposition.
Certain provision. So therefore, unless and until we go through the other judgments on the basis of which it has been founded on, this cannot be said to be a certain provision, but judicial note of, we can take a note of it that this law has been settled by the Honorable Guwahati High Court.
So many matters it has been settled by writing without referring to any judgment, just writing a line. Now it has been settled. Proposition of law will not make that proposition settled.
But the quotation should have been mentioned in this case that I cannot comment upon it.
Not only quotation, not only the judgment should be referred to, but you have been arrived at those two judgment
that
in which judgment of the
those things should have been mentioned. Those things should have been mentioned.
And your task would be that this compensation, this word compensation in 171 is inclusive of which factors? And which factors it excludes?
But in that case again, the Sushma Thomas case and the Charlie versus Charlie and Devu, in those cases, the Honorable Supreme Court,
You bring that, read that.
because after the Pranay City, we have left reading those judgments because in those judgments, Your Lordship,
No. Why should we leave reading those?
no, because in those judgments, it has also been held that in case of Sushma Thomas, as far as I remember, in that case, the fact is that the husband of Sushma Thomas was the media man and he was working in India. He met with an accident and his assignment was made to the US or some European countries. Therefore, the Honorable Supreme Court in that case has added a future prospect of that income in relation to what he would have got in the
What do you understand by the term compensation?
compensation is to make good the loss which the person would have suffered or would suffer. Compensation.
In normal parlance.
In a normal parlance. It is a normal parlance. But so far the
Now, whether there is only one component of compensation, in the word compensation, or there are several components?
yes, in that case also, in some of the cases, in some of the cases, with utmost humility and sympathy, that there was argument by the councils on that basis that future prospect, if he would have been working there, he would have given. Therefore, the Honorable Supreme Court, some of the future, one is not about of the future. Suppose if future he might have been terminated from the service, he might have died or he might have left the service. Therefore, that part is not to be taken into consideration. But unfortunately, unfortunately, that issue was not argued in the Reshma Kumari in all those cases.
Is there a strategy? When an interest is granted,
Now, let us
when has the court the power of the court to grant it?
to grant interest. Let us take a review of the help of CPC for section 34
CPC is there, or the Interest Act?
or the interest act.
Read CPC first.
Section 34. Section 34.
Section
34.
34. Read section.
Where insofar as the decree is for payment of money, the court may, in the decree, order interest at such rate as the courts deem reasonable to be paid for the principal sum.
Don't very further. Listen. Where and insofar as a decree is for payment of money.
In addition to any interest adjudged on the principal sum.
Court may in the decree or order order interest at such rate. That means where and insofar as a decree is for payment of money.
Now,
So my next question would be whether this component of future prospect will not cover is not a part of the decree.
it is a part of a decree. I am coming to that. It is a part of a decree, but it is something more.
No. What you are saying is a method of calculation. What you are saying is a method of calculation. I am asking you this question. You just note down all these questions because you have to answer, not like this. That a degree is for payment of money. That means if you say this 20% or 30%, say suppose it's 1 lakh. This amount of rupees 1 lakh is not a degree in terms of section 34. Will not be a part of degree section 34. Then only, if it is not a part of degree, then only it can be excluded under section 34. Then you have to answer, you have to say, this will be your proposition, that this amount is not a part of degree.
No, then I cannot say.
No. You find it out.
I
Maybe
cannot
you
say.
can say.
No, I cannot
Maybe
say.
you
I
can
will
get
not- I will
a certain
not-
proposition of law on this.
But I will not say it is
Maybe
not a
you
part
can
of
get
it.
one certain proposition
It
of
is
law on
not a
this.
part of
Now,
degree.
now come to section 3. Any proceeding for the recovery of any debt or damages,
Yes.
or in any proceeding in which a claim for interest in respect of any debt or damages already paid is made, the court may, if it thinks fit, allow interest to the person entitled to the debt or damages, or to the person making service. Then, is this part a debt? Then this is not a debt, not a damage.
Not
It is
a
not a damage.
No, at
Then
one.
it is not a damage also what you are saying. Just
No,
think.
it is-
So you don't have to answer immediately.
No, it is.
You don't have to answer.
No, it is a damage. It is damage. A damage is caused to the family. I cannot say it is a damage. It is damages. It is not the damage. It is the damages which you are paying.
Now the question is that if a damage is computed it's actually, notionally, or on by way of assumption, how much time you ask?
So it has been answered by.
How much? This has not been answered, sorry.
let it be after summer vacation. अब अभी नहीं कर पाएंगे अभी. This will require time. This will. I'll have to consult some of my friends also.
अच्छा देखो पार्ट
हाँ पार्ट में दिया. हम थोड़ी भाग रहे हैं.
आर्ट इन पार्ट
हम थोड़ी भाग रहे हैं.
आर्ट इन पार्ट
हम भाग थोड़ी रहे हैं. और एक और
as
who can
Mr.
give it?
Alok Lal has raised a question which needs to be answered.
four questions.
The question which Mr. Alok Lal, counsel appearing on behalf of the appellate insurance company raises is that the compensation on account of future prospect, which is granted in terms of the judgments delivered by the Honorable Supreme Court is in the case of Pranay Shetty and others. The component of future prospect should be kept out of purview of section 171 of.
No, out of interest.
What is
Not
171?
interest.
What is 171?
Actually,
Should be kept out of purview of section 171 of the Motor Vehicle Act and will also not be considered under section 34 of the CPC or section 3 of the interest. He submits that by calculating interest in terms of section 1 of the Motor Vehicle Act, the amount which is quantified as compensation under the head of future prospect should be kept out of
section 170.
purview of while calculating interest. Seed amount will not carry any interest. This is
And second question with regard to the rate of interest.
rate of interest, that you can say that.
No, but you make as let it keep open. Let that part be kept open.
He further argues that the rate of interest
9%
should not be 9%,
as per the bank rate.
and should be as per the
Bank deposit rates.
bank deposit rates.
That will give both of us and Q to argue on that.
You will set a proposition.
I
You
will
know the
not.
proposition.
I will argue, but
Anyone.
after vacation.
This is after vacation. Have you received any money?
2 लाख दे चुके हैं इसके अंदर.
Huh?
2 लाख दे चुके हैं. नहीं sorry 2 लाख से है चुके हैं.
26 लाख मिल चुका, 20 लाख
26 मिल चुका है इनको.
20 रखे हुए हैं।
20 बाकी है.
Please दे दीजिए. Please दे दीजिए.
अभी से लेते हैं. कोई दिक्कत नहीं. 20 ले लें.
That is the principle.
नहीं कहाँ दिक्कत है.
The
बड़ा कहाँ है.
balance 20 lakh rupees should be paid to the, in the meantime, the balance 20 lakh rupees should be paid to the payers. That the insurance company.
So on the point of interest, I have been able to find out some of the judgment of the Honorable Supreme Court.
After vacation.
After.
Of telling always under the heading of restriction, serial number 1.
आप भी थोड़ा खोजिए आप भी थोड़ा खोजिए प्रोपोजिशन ऑफ लॉ में नया आर्गुमेंट आप वापस करें ना ये
इतनी पता है लेकिन हम
इंश्योरेंस का इतना केस किए हैं कि उनके सामने तो हम कुछ नहीं है।
ऐसी बात नहीं है. ऐसी बात नहीं है.
this proposition of law has got nothing to do with it. It is rather interpretation of section 171
Yes.
34 of the CPC and 3 of the interest.
Yes, I will see also.
Whether it is this case, the
Negative cannot be proved.
Yes.
Negative cannot be proved.
Negative cannot be proved.
Positive can be proved. So onus is upon you. Yes.
The defects, Wakala and other, some of the defects have
So remove the defect. 2
Yes, sir.
weeks. 2 weeks. 2 weeks. 2 weeks to remove.
removed.
18. Yes, currently. 2018.
Correctly मत किया जाए।
No, 2018 है. 2018 is current.
अच्छा।
Serial number 2, second appeal 238 of 80, Mr. Anand Sharma.
this case, there are some defects which was to be told by the code below.
Code below.
Yes, sir.
Which one?
It has gone there also.
Unit number? Unit number 2, in respect of unit number 2, the document we sent to the code below. 2 and 3. The rest within 2 weeks.
This has been done, madam.
The other things.
Defects, other defects have been,
Here.
yeah, I will do that.
Serial number 3, second appeal 239 of 18, Mr. Aziz Jha.
Certain defects have been pointed out with regard to filing of the certified copy of the degree also.
No problem. This is of 2000?
2018.
2 weeks currently.
इसमें my audit clear will be 4 weeks कर दिया because certified copy.
4 weeks.
इसमें certified copies will
4 weeks. This is 2018. You cannot
By
take
way of
shelter
last
of COVID.
intelligence will not.
You cannot take shelter of COVID. It's 2 weeks currently.
Serial number 4, second appeal 261 of 18, Mr. Mohan Prasad, Mr. Sandeep Verma.
Nothing? To go before the court below? 2 weeks currently, no one appears. However, 2 weeks time currently is not difficult.
Serial number 5, second appeal 263 of 18, Mr. Ganesh Prasad Roy.
2 weeks time.
2 weeks currently.
Serial number 6, second appeal 271 of 18, Mr. Hemant Kumar Shikarwar for appeal.
Put up next time, sir. 4 weeks. 4 weeks.
4 weeks. 2 weeks currently.
Nice.
Serial number 7, second appeal 283 of 18, Mr. Satish Kumar Ugal, Mr. Thomas Kabinet for appeal.
Currently 2 weeks.
Madam, Mr. Santosh Kibral is appearing in this case. He's having some problem in his
2
eyes.
weeks currently.
Madam, 1 week after vacation, madam, time table.
2 weeks currently.
Serial number 8, second appeal 288 of 18, Mr. D.K. Chakravarti.
2 weeks may be gone.
2 weeks currently.
Serial number 9, second appeal 329 of 18,
2 weeks currently.
serial number 10, second appeal 359 of 18, Mr. Sen Mishra, Mr. Gaurav Vijay.
2 weeks.
2 weeks currently.
Under the heading for order, serial number 11, second appeal 228 of 50, Mr. T.L. Jha for appeal.
Crossover, no one. Crossover.
Serial number 12, second appeal 603 of 50, Mr. Neeraj Kishore for appeal.
We have one IA loss. IA for substituting the legal of respondent number 7 loss, who died in independence of the second appeal loss. We have one IA loss, that IA number 4163 of
4163 of 17.
Yes, loss. For substituting the legal of respondent number 7 loss. Incidentally, in the memo of appeal loss, respondent number 7 could not be
17 or 7?
17 loss.
17.
loss. In irreversible lossing, in the memo of appeal could not.
When did he die?
He died on 12/2/17 loss, and we filed this IA on 9/5/17 loss. He explained the paragraph 4 loss, the legal year respondent 4 loss.
Even though this application is prepared to substitute the deceased respondent number 17, namely Bharachan Mahato. He died on 12/2/2017, leaving behind paragraph 4, 1 to 3. The substitution petition is well within time. the right to sue survives upon the legal rights. Considering the opposite act, this I is allowed. So it's just substituted for the legal rights. Necessary correction. Writing 2 weeks. And it's possible.
Serial number 13, second appeal 609 of 50.
Placement notices were issued to the respondent lordship. As respondent number 5, 6, 7 appeared.
They are here.
Not appeared. Respondent 1, 2, 4 appeared lordship.
Fresh notice to respondent number 5, 6, 7, 8 on present and correct address. Registered ordinary, both requisite 6 weeks. Present after ascertaining present and correct address.
Serial number 40, second appeal 627 of 50. Mr. Kaushik Sarkel for appellant.
Yes.
Lordship, there is a notice has to be sent for respondent number 12 and 13.
Respondent number
11 and 13.
No, Madam, may kindly appreciate order dated 24/11/2021.
12 and 13 received by the father. Yes. Order dated
Order dated 24/11/2018.
24/11. 24/11/2018.
8/21.
24/11 the case was not fixed on 24.
The last order, my lord.
It's 25.
25.
Correct your records. Yes.
Well, they have taken time for whether they will possibly matter or not. On that occasion, they have said.
Yes.
I have to seek instruction, Lordship.
What is Mr. Sarkel? What is
Mr. Kaushik Sarkel, you quote number 3, Lordship. Just a password.
password?
Serial number 50, second appeal 632 of 50. Mr. Om Prakash Singh.
इसमें प्रेजेंट एंड करेक्ट एड्रेस के लिए बहुत ऑर्डर हुआ था उसमें पहले 2 दिन डिले फाइल हुआ 3 days notice
Delay.
yes sir 4
We
weeks
file the
time
notice.
notice जो 3
The
दिन बाद
notice, the office is directed to proceed with the requisites, which has already been filed.
Serial number 60, second appeal 41 of 60. Mr. Seth Gautam.
In this case, one substitution application has been filed. One substitution application has been filed, madam. In addition to that, it has to be filed, madam. But in the earlier date, madam, we had raised a question regarding that the legal heir which has to be substituted, where are legal representative of the petitioner or not, madam. In this case, madam, the original petitioner, madam, he has representing the deities, madam. The suit has been filed in the representative capacity, madam, under order 128, madam. Compliance for the order rule 18 has not been mentioned in the court below order, madam. Whether the compliance.
The plaintiff is the DT.
DT.
Plaintiff is the DT means, okay. So now, the one
Yes, sir.
represented the DT.
Yes, sir.
This person, Purna Chandra Valad, died.
Right.
Now, whether this
Where question arises as to whether any person is or not legal in the view of a deceased plaintiff or deceased defendant. Such questions shall be determined by the court. Provided that such question arise before the appellant court, that court may before determining the question.
Mr. Counsel, just this Purnachandra Halda,
he is also a complete stranger, madam. That is our case in the court below us. For filing a representative suit, my lordship, compliance of order 128 has to be done, madam. But that has not been complied. Both the court below order, my lordship, nothing, no issue has been framed in this regard also, madam.
no, see, there are two ways. See, one is Purnachandra Halda
Yes, madam.
as the representative capacity of the villagers, and the second, the same person, as representing the deities. So he is representing both of them in two different capacities.
Yes, yes, madam.
Now this Purnachandra Halda dies.
Yes.
Now if he dies, now he may not, his son or anyone may not be representing the entire village. The entire village may say no, he will now, A will represent the entire village. So far as that is representing the villages. But what happens when the person is representing the minor deity? Tell me.
My lordship, in that case, my lordship, order 128 has to be complied with. Can you look at what
No,
order
Order
128?
128, what does order 128 say?
Yes. Savers, my lordship, are the original
Sevites.
Sevites can represent my lordship.
Yes. Read that.
Order 128 I am looking at. One person may sue or defend on behalf of all in the same interest.
On behalf of all he is having the same interest. Here he doesn't have any same interest. This,
Yes.
what is the deity? Who is the deity? Deity is a perpetual mind.
Yes, sir. Yes, sir.
So he has to, the deity has to be represented to the next friend.
Next.
So who is the next?
Saver, my lordship.
Now he's dead. Now who is the survivor?
He was never declared
Survivorship is by hereditary.
Purnachandra Halda was never declared survivor. The court will order no finding with regard to that, my lordship, that he is the survivor.
You are the plaintiff?
Yes, he is the plaintiff.
You have tried this? Now who is the survivor? Who will represent the...
Since the daddy has already passed away, now
Who has passed away?
Purnachandra.
Original plaintiff.
Yes. The original plaintiff passed.
This Samiti.
Just a minute. Yes. You are representing who, Mr. Adesh?
Mr. Purnachandra. And this one is not
You are representing whom?
on behalf of some Samiti.
Yes. You are representing three.
That is true.
You were representing one group and two persons.
Yes.
Two minors. Okay. So, Puranchand Haldar is there. That is representative of the villager is there.
Yes.
But 2 and 3 is not there.
2 and 3.
2 and 3 is not there. But now who will represent 2 and 3? You can?
Yes.
You can.
My son is correct. Since the Puranchand Haldar is represented through in representing capacity, he has this through
Affidavit. I don't know who is the member of the
So
subcommittee.
this is not me.
You file an affidavit stating that who will represent 2 and 3. Mr. Ajay Shah seeks for 3 weeks time to file an affidavit. Bringing the notice of the spot that who represents the plaintiff 2 and 3 and the villagers of the village Daya. If you file the petition, you file an application if it doesn't matches with your. This is of 3 weeks.
3 weeks, madam.
3 weeks. And there will be another time
Yes.
that someone will say that I will represent, another will say I will represent them.
We are complete stranger. This is our case. I have the resolution is with me, but that must be given to God. That's how I decided who will represent me. All that.
Yes.
Serial number 17, second appeal 309 of 60.
In this advocate second appeal matter, notices were issued to respondent lordship. Respondent number 1 to 8 appeared lordship. And so far as respondent number 13 is concerned lordship, he refused to take the notice lordship. And respondent number 9 to 12 and 14 has not received notice lordship. We have also filed one IA lordship. IA number 7.
Your opinion on paper 1 to 8.
1 to 8.
What happened to 9?
9 refused to accept.
13
refused to
accept.
accept.
13 refused to accept.
My lord.
9 to 12 and 14 has not been received as yet as per the report of the service.
Yes, lordship. We have filed one IA lordship.
Serial number 18, second appeal 446 of 60. Mr. Prashant Palla, Mr. Sanjeev Nayak, for appellant. Serial number 19, second appeal 502 of 60. Mr. Lalit Kumar Lal, for appellant. Serial number 20, second appeal 519 of 60. Mr. P.K. Sinha. Serial number 21, second appeal 560 of 60.
You filed a substitution petition.
Actually, when it's a petition and you can file on behalf of the pleader, on behalf of the deceased respondent, defendant, or by the pleader of the defendant respondent.
So you have to file a substitution petition.
May I explain my question? That when the pleader has given information with regard to death of the sole defendant respondent. Now, in view of Order 22, Rule 4, if Lordship may kindly peruse. Rule 4, if Lordship may kindly peruse.
Yes.
Rule 4, by which may kindly peruse.
Yes.
And also, death marriage and or dependent alone, or a sole dependent or sole surviving dependent dies, and the right to sue survive the court on an application made in that behalf shall cause the legal representative of the deceased dependent to be made a party and shall proceed with the suit. So in view of this, Order 22 holds, in my humble submission, when the leader of the defendant, respondent, has given information to this court with regard to death of the legal, I don't have any objection whether if the legal heirs of the respondent is substituted.
File an application.
Then the applicant has to file it.
Then, it goes to file. Read 10A. Read 10A.
A.
Yes, 10A.
Then
If I am not wrong.
duty of pleader to communicate to court dates of the court.
Read that after, whenever.
Whenever a pleader appearing for a party to the suit comes to know of the death of that party, he shall inform the court about it, and the court shall thereupon give notice of such death to the other party. And for this purpose, the contract between the pleader and the deceased party shall be deemed to subsist.
Then, the deceased party's contract is only till giving the notice. Thereafter, the contract comes to an end. How he can move application and, for substitution?
Then all right, when is 3 weeks time, he can be given me 5.
How can I grant you 3 weeks time, sir? Statute grants you time, who am I to grant you time?
Madam?
Statute grants you time.
No, that is 90 days from the date of
So
the.
that if you don't file within, the consequence will follow, there is a remedy of the consequence, which the court to
From
grant
the
you time.
information given to this.
Court can condone the delay, court cannot extend the limitation. Court can condone the delay if there is a condonation petition under section 5. Court cannot extend the limitation by granting you 10 months to file. Can this be a valid order? That I grant you 2 years to file a substitution petition. Will be a valid order. You are asking for time, and I grant you 2 years time to file a substitution petition. But if you file a substitution petition after 2 years, coupled with a limitation application and a setting aside abatement, I can pass an order on that I can set aside abatement and I can condone the delay. This is within my power. I can't have any power. I don't have any power to extend limitation.
All right, on the basis of this.
I will not say anything.
All right.
In view of the office not learned senior counsel based on some time is about. This case is actual. This is the only order I can pass.
My question.
While exercising jurisdiction under CPC. In 227, the matter would be different. While exercising jurisdiction under the CPC. In 226, I may help. Yes, next.
Serial number 22, second appeal 563 of 16, Mr. Yaswardhan.
Yes. Respondent number 1 received by son, 2 received by son, 3 received by himself. Take down. The notice upon respondent number 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. Service of notice upon so and so is started. You are appearing on behalf of 12. Respondent number 12. 12. Process appears on behalf of respondent number 12. Service appears on behalf of respondent number 12. Okay. The respondent number 4 to 7. Substitution.
Limitation.
How many?
12 days delay.
12 days
Wrongly,
delay.
I have stated 16 days.
There are 12 days delay in filing this appeal. After going through the application under section 5, paragraph so and so to so and so, I find sufficient ground has been shown to condone the delay condone.
Obligation.
Serial number 23, 2nd April 588 of 60, Mr. Vijay Kumar Sharma.
During financial literacy, a plant number 1 by diagnosis. ILOC had been discussed also. Wife of the plant number 1 was also diagnosis. So,
This is an admitted appeal.
lots.
Who is dead?
Plant number 1 university.
No death certificate annexed in the IA petition.
No death certificate annexed. That means you are doubting the death or the date of death. What are you doubting? You are doubting the death or the date of death for the purpose of limitation. What are you doubting? What are you doubting? If you say the death certificate has not been filed, that means you are doubting two facts. Either two, either one.
I'm saying only for proof.
He is saying that means you are doubting death.
No, no.
You say that he is not dead, then you will fight. If you are saying that the limitation is not only 42 days, it is for 20 days, then you say that. I don't change it.
Lordship,